My name is Stefano Burchi. I'm a national of Italy. I am currently the chairman of the International Association for Water Law, and I have made a career in the Food and Agriculture Organization of the United Nations in the legal office as the in-house legal specialist for freshwater law, national, domestic, and international. My talk will be about the future directions of domestic water law into the 21st century, how water law addresses and responds to the challenges ahead in the 21st century, resulting from essentially the pressures on available stocks of fresh water, which are pretty finite, renewable but basically finite, against the ever-increasing demands placed from a variety of user sectors, including the environment, and against the threats that come to available volumes and flows from climate variability, but also on the quality of fresh water due to pollution, a variety of pollution sources. How does water law respond to these challenges, looking into the future, into the 21st century? Well, first, by the first response and the first trend that one detects is canvassing water resources under the cloak of the state public domain. Water is increasingly, freshwater, surface, but also underground, is increasingly being attracted into the fold of the public domain of the state under a variety of legal constructs, depending on the different legal systems, common law, civil law. But the trend is the same across all jurisdictions. Water is becoming increasingly an item of public property in one form or another, under straightforward state ownership or public trusteeship, public guardianship, with the consequence, with the result that private individuals, corporations, can only have user rights in the resource. Now, there are pockets where private property of especially groundwater still persist, notably in India and in the state of Texas in the US. However, by and large, the trend is towards attracting water resources in the fold of the public domain of the state. And another parallel trend is to cast the net wider and wider, moving from water in rivers and lakes and in aquifers to treated wastewater and to water in the atmosphere, if not all the way to water in glaciers. In parallel with this comes also a trend to turn the mechanisms, administrative mechanisms for the regulation of the allocation and use of available water resources, and making these mechanisms, notably licenses, concessions for the abstraction of water resources, more flexible and adaptable to changing circumstances. Changing in the light of change in economic policies, political priorities, but also technological advances, and last but not least, surely, climate variability, the variability and the uncertainty induced by climate change, climate variability. Now, there are a number of instruments that in contemporary water laws that provide an indication and evidence of this increased move towards adaptability and flexibility of water abstraction, permits and licenses and concessions to change. And one important direction of this change is towards the review and the diminution of grants made. And for instance, just to mention an example, there is a very sort of cutting edge response of laws, of contemporary water laws in this direction to accommodate the concern for adaptability and flexibility is the shift from fixed volumetric allocations of water for abstraction to share-based allocations, where essentially one no longer has a right to abstract a fixed amount of water, but rather a share in an adjustable availability, changing availability of water, changing shares, adaptable shares. Another distinct trend that one detects in contemporary water laws is the rising profile of the human right to water. The human right to water is, in contemporary water laws, moving from, if you like, the limbo of international pronouncements, finding its way into mainstream water laws, and at the level of policy and principle, but occasionally for the moment, and perhaps exceptionally, also at the level of some operational detail. Another trend that one detects in contemporary water legislation is, in response to the mounting pressure over fixed volumes and fixed stocks, is the quest, if you like, the search for efficiency of allocation, where allocation of available freshwater stocks goes to the more or the most efficient utilization of freshwater resources. And one instruments to achieve that one sees more and more in contemporary water laws is through the trading of water concessions and abstraction concessions and permits. Now, because there are, or there can be third-party effects of trades of water rights, water abstraction rights, these the trading and the markets, I'm sure you've heard about markets, water right markets, tends to be controlled. In other words, there is always a sort of a government scrutiny of proposed trades before water can shift from one user to another, and maybe even from one sector, notably irrigation, irrigated agriculture, to another sector, notably municipal use. There is only one case, one country in the world, Chile, where trading can be freely practiced without any form of government control, but that's the exception. The rule is controlled trading. Another very prominent trend in contemporary water law is in the direction of capturing the role of the environment, if you like, environmental water, water for the environment, and the ecosystem centrality of water resources in contemporary water laws. The environment becomes, as a result, and is recognized, acknowledged as a legitimate competitor for dwindling water stocks, alongside and on a par with the developmental uses of water resources for irrigation, hydropower generation, municipal water use, and all of that. So the environment has come to compete with these other uses and is being granted and given prominence on a par with, as a competitor alongside with, other user sectors of the freshwater, available freshwater stocks. The evidence of this and the instrument whereby environmental water, water for the environment, is being given this recognition and prominence are very, very many and vary across, quite a wide spectrum. Perhaps the most prominent are the mandatory ecological flow requirements of watercourses, rivers, the reservation setting aside volumes and flows for an environmental purpose, environmental conservation purpose, Another is the grant of water rights and water entitlements for environmental purposes on a par with grants of water rights for other traditional consumptive uses. And with the novelty that these grants for environmental purpose, are nowadays being held by an environmental water holder. In other words, a new entry, if you like, in the known constellation of governmental water institutions. This is the case notably in Australian jurisdictions, where you have this new figure, this new entry, the environmental water holder. Another evidence of this rising role of the environment is through the recognition, which is contemporary, recognition of rivers as legal persons, which you see in New Zealand, in India, in Colombia, and even in Ecuador, where in fact it is the Mother Earth, Pachamama, which is being granted legal personality. And in parallel with this goes the entrusting of these rights into institutions or persons that act as guardians for rivers, lakes, which are granted legal personality. Another trend is towards bridging the traditional divide that exists in regulation between water and land. Now, there is an intimate relationship in nature between water and land, and one can only think of, for instance, at points of intersection, of a number of points of intersection where land and water meet, notably in, for instance, in the floodplain of rivers, with the necessity for flood control and flood risk mitigation, in the pollution of water resources, especially groundwater from diffuse sources, such as the runoff from irrigated agriculture or stormwater runoff. Now, these points of intersection in nature, another is actually the impact that land use activities above ground and underground have on the natural processes of recharge and discharge of groundwater. Now, there are here issues of interface and interaction which tend to be increasingly captured in domestic water legislation and land use planning laws by pulling them together and bringing them together under one consistent, sometimes interlocking network of regulatory obligations and regulatory controls. So the effort is there, and the ultimate goal is to make sure that both sets of regulations work towards a common purpose and don't work at cross purposes. Another very important forceful trend is the capturing, canvassing in the realm and in the fold of statute law and statutory dispensations, the role of customary uses, customary water rights and practices practiced on the ground in so much of the rural but also peri-urban areas of much of the developing world in Latin America, Africa, Asia. Now here you have a panoply and a range of responses in regulatory legislation that ranges from a blanket sort of recognition of customary water rights to more articulate forms of recognition of these customary rights and practices, with a view to what? With a view essentially to minimizing the potential for conflict between customary practices on the ground and formal water abstraction rights. Now, another point is the increasing role of water users in the governance of freshwater resources. Water users on the ground are being called upon by water laws to take up a greater share of responsibilities, increasing share of responsibilities in the governance and management of water resources. In particular, my mind goes to groundwater, where associations, formal associations of groundwater users are being increasingly called upon to exercise certain functions, like notably restraining extractions and policing, which are generally government functions, but that are best performed, more effectively performed at ground level by associations and groupings of water users. Another manifestation of this, of the role, of the mounting role, if you like, and profile of water users is through the membership structure of river basin organizations and entities that are taking, more and more of a prominent role as the, I would say, the main line of direction of the evolution of the government water administration, freshwater administration, and where you have a whole variation, around this theme, but where there is the constant element throughout across the whole spectrum of variations on the theme is the role of water users. Water users have a role to play and are called upon to sit in the bodies that make up the internal structure of even the most elaborate of these river basin institutions. And last but not least, another interesting trend that one detects in the more recent generation of contemporary water laws is what I could term facilitating, if you like, access to justice in water disputes. Because you see more and more in contemporary water laws attention to alternative dispute resolution mechanisms. So water laws encourage recourse to ADR mechanisms and resolution of disputes at local level, community level, by communities themselves. And by doing so, essentially, it is not that contemporary water laws try and bypass, short circuit, if you like, the role of the formal courts of law, but it's they try essentially to facilitate access to justice, especially at the tail end of the spectrum of water users out in the rural areas, and sparing the smaller users the aggravation, the expense, and the uncertainty of long drawn-out battles in the formal courts of law. So where does all of this lead us to? What are the, how could one sum up, if you like, the main challenges that emerge from this bird's eye view and recollection of trends in contemporary water law in response to the challenges ahead of us into the 21st century? Surely one is the issue of the challenge to respond to the need to reconcile the security of tenure of water rights with the risk and uncertainty which is inherent in the availability of water resources as a result of notably climate variability and technological change and change in economic and socio-political circumstances. How does one respond to this challenge? So reconciling security, which is sought by users and investors in particular, with uncertainty and risk brought about notably by climate variability. And we have seen a number of responses in contemporary water laws to this challenge. The profile of the human right to water, moving from the level of a statement of policy and principle towards rather operationalization on the ground. There is still a lot of work lying ahead on this particular path. But the trend, and the responses that you see in contemporary water laws to this particular issue are encouraging. Another challenge is reconciling efficiency of allocation of a scarce resource with equity. And the general trend and direction in response to this challenge is, yes, contemporary water laws pursue efficiency of allocation, but not to the neglect of equity. Equity is always there. Equity looms large in the discourse about efficient allocation of water resources. Another challenge is reconciling the environment support function of water resources and the ecosystem centrality of water resources with the developmental function of fresh water. How to reconcile the demands of the environment and of the ecosystem with the demands coming from development, socioeconomic development sectors, irrigation, hydropower generation, municipal use, industrial use, and all of that. And we have seen, and there are a number of responses that, a number of very articulate responses that contemporary water laws provide around this theme in response to this challenge. Another challenge is reconciling the land use spatial planning regulation with water resources management regulation. And here there are very interesting indications in contemporary water law and in parallel in contemporary spatial planning laws that point towards the way of reconciling, coordinating, if not on occasion consolidating the two traditionally separate strands of regulatory legislation in recognition of the very intimate relationship that there is that links and binds water to land in a number of respects. Another challenge is the potential, minimizing the potential for collision and conflict between formal water abstraction rights granted notably to investors from home and overseas. One can only think of the land grab, land cum water grab, with the traditional customary practices on the ground which are practiced in much of the rural areas of much of the developing world. And now contemporary water laws are moving in the direction of providing a rather articulate set of responses to this very, very thorny and very, it could be quite an intractable issue, if you like, as also the experience of countries like notably Canada, the westernmost provinces of Canada indicates, where there has been a lot of litigation in front of the courts of law to seek where, tribal users, customary users have sought recognition of their rights in water through the formal process of litigation in the courts of law, which is time-consuming, expenses, not easily accessible, and unpredictable in its end result. And in response to this, in fact, you have a trend, the challenge, if you like, the parallel challenge is to facilitate access to water justice in towards the settlement of water disputes, especially out in the rural areas where the courts of law cannot be easily accessed, not accessible, so easily accessible to disputants and litigants, and where, as a result, there is an obvious opportunity and need to facilitate and to provide locally based means of informal dispute resolution that get recognition in the formal water dispensations. And this is another very distinct, the challenge and, a trend that one sees emerging in much contemporary water legislation. In essence, and to conclude, I would like to conclude perhaps on a positive note and on an encouraging note, but with a caveat at the same time. I mean, as contemporary water laws moves into and develops and fashions more and more articulate responses to the challenges ahead in a variety of domains, and especially as regards the allocation, the management, and the allocation of fresh water, but also in respect to the protection of water quality from different sources of pollution, the most insidious of which, remember, is diffuse pollution. Now, how would I say, the increasing complexity of the responses that you find in contemporary water laws to these challenges call for a coterminous capacity in the government water administration to manage, to implement, and if need be, enforce these instruments. In other words, the administrative regulatory instruments that contemporary water law is fashioning for the use of government water administrators, but also for the use of the user population, are becoming increasingly more sophisticated. And sophistication in turn implies the capacity of government water administrations, but also of users, to internalize these instruments and to be able to respond effectively to them. And this is an area, if you like, i.e. implementation of water laws and enforcement, that calls for a lot more attention than so far. And it's one field, if you like, of water law that has been much neglected so far, but it still is critical, absolutely critical, for water laws to make an impact and to be able to respond effectively to the challenges ahead. Thank you very much.